All right, you are watching a live broadcast of a live radio show in St. Louis, KTRS Radio on KPLR Channel 11.2. If you have Charter, it's Channel 187. You can download our app anywhere on your smartphone. And yes, even Tom Brady's new smartphone, an old smartphone, can download the KTRS app. Just search the App Store, search KTRS, download the app, works anywhere in the world. And, of course, 550 on your AM dial, stltoday.com. and at KTRS.com. Joining us now, you've heard all around from all the other media outlets, attorneys, so-called experts about the Tom Brady decision. We decided to go with our expert because, quite frankly, we're biased. We think he's the best. Greg Willard, you are a professor at St. Louis University Law School.
Law School.
You worked in the White House, and you weren't a White House attorney, or were you a White House attorney?
Was not.
You were not a White House attorney.
White House staff assistant.
White House staff assistant. You then became an attorney for Gerald Ford. Mm-hmm. Okay. And you are our KTRS legal analyst. How shocked were you that the judge overturned an arbitrator's decision?
Very surprised.
Okay.
The sort of the standard in America, particularly with federal law, McGraw, is for a federal court to overturn an arbitrator's decision is an extraordinary event. It happens, but it's extraordinary. I would say probably less than 1% of the time. So just on that basis alone, I was very surprised.
So because it's happened so rarely, one would think that Tom Brady was so egregiously treated that there was no other option than to overturn the private decision of his employer.
I think your summary is very accurate. I think in so many words, Judge Berman said Brady was egregiously treated in the process.
Right.
He was egregiously treated in that he did not have the opportunity to examine Jeff Pash, the NFL general counsel, who the judge found was a co-investigator.
Right.
And secondly, Brady was not allowed to review the investigator's notes of the investigation. Those circumstances led, I'd say primarily, to Judge Berman concluding that the process violated basic fairness, and he vacated the award. Okay,
so three buddies of mine go in and we rob an ice cream store. And the two buddies go in, they sing like a canary. I go in and I say, hey, wait a minute, I want to know what those two guys said before I make my testimony. At some point, if Tom Brady knows what everybody else is telling him, then he can come up with some other story. If you're trying to get to the facts, and this isn't a court of law, this was the NFL doing their own investigation, why would the NFL tell Tom Brady what they've already learned? Why wouldn't they come in, have him tell his side of the story, and then sort of piece together who's telling what side of the story?
Two different contexts. The context you just raised was in the investigative context. So when Ted Wells was doing the investigation,
right.
What you just outlined is absolutely correct. When the police officers and the detectives are investigating you and your buddies doing the strong arm robbery, they're not going to tell you what your buddies have said.
Right.
Once you get to the courtroom, or in this case, McGraw, the arbitration hearing, that's where the judge said, Brady is entitled to see the investigator's notes because the investigators are going to be using those notes to cross-examine him in the hearing.
Gotcha. This was a negotiated part of the NFL's agreement with the players that the players wanted Roger Goodell not to have as much power. The NFL owners wanted him to in terms of disciplinary. So they negotiated and they gave up. They said, all right, we'll let Goodell be the ultimate decider if we get X, Y, and Z. The judge didn't rule that Goodell violated the agreement. He ruled that the agreement is wrong. Is that a question?
No, I wouldn't. No, I think he didn't. Well, let's back up.
Yeah.
It's a collective bargaining agreement. There are thousands across the country in operation today. Millions of Americans work in the context of a collective bargaining agreement. It had a mechanism, which you pointed out, that said, in disciplinary matters, there is a procedure ultimately resulting in an arbitration. It also said that the commissioner may be the arbitrator.
Right.
What Judge Berman yesterday said was that whatever the union gave up, whatever the owners gathered, but that process has to be fundamentally fair. The arbitration process has to be fundamentally fair. And the way the commissioner conducted this arbitration process was not fundamentally fair. Therefore, under the Federal Arbitration Act, the judge has the power to vacate that award because the process was not fundamentally fair to Brady.
So basically, he's saying that Goodell was not fair when arbitrating after the suspension came out. This was the appeal,
right,
of Brady.
That's the point, McGraw. It's not. He didn't take. Judge Berman did not take issue so much with the investigation as with the arbitration itself that the commissioner conducted in June. And what he was critical indirectly of the investigation because the commissioner has made a big point publicly that this was an independent investigation.
Right.
Well, the judge, almost in a mocking fashion, put quotation marks around independent throughout the opinion. But in the end, his analysis rested on not whether the investigation was fair, but whether the arbitration that the commissioner conducted was fair. He found it was not, vacated the award, and as we heard, the NFL has already appealed.
Right. Okay. So the not the initial Wells report and not the official 4-game suspension, but when Tom Brady appealed that suspension, that went to the arbitrator. Roger Goodell named himself the arbitrator, and that was the issue.
The way that the issue then was
how that arbitrator then decided the appeal.
Yes.
Right.
In other words, how he comported himself in the arbitration in June, Judge Berman ruled was unfair and violated basic due process.
The judge begged both sides to come to an agreement. I said, go into a room, figure it out. He did not. Sounds like he did not want to make this decision, and both sides felt so strongly that he was talking about the other side.
It was remarkable the lengths he went to try to precipitate a settlement. He brought the commissioner and Brady to the courthouse.
Right.
To try to be facilitative of a settlement. Neither side would budge. I think it tells you something, certainly, of the league's view, McGraw. The ink wasn't even dry on his decision, and they file a notice of appeal to the Second Circuit.
Right. Okay.
Wow.
Now, let's talk about this for a second. They could have asked for a stay, right?
Right.
Or an injunction, or whatever you smart people call it.
Stay. Yeah.
Which would have said what? So then that would have gone to a court, and then a court would have had to decide whether or not that was legal.
They could have asked Judge Berman to stay his ruling pending the appeal. If that had been granted, then Brady's suspension would have gone into effect for the first game.
Gotcha.
That is a very, very high standard, and I think the league simply decided
they can't
enough
win that.
Already.
Right.
They moved within hours to take the appeal to the full circuit. So Brady will play pending that.
Right. Okay. How long, Greg Willard, KTRS legal analyst, St. Louis University law professor, all-world, all-knowing, how long is the Second Circuit going to take to rule on this?
The median time for appeals being decided, McGraw, in the Second Circuit is 10 months. Could take less, could take more, but I would think by early summer next year, we could reasonably expect an answer.
The NFL wanted it in the Second Circuit. Why?
In recent years, the Players Union has brought this litigation up in Minneapolis and has received many favorable rulings.
Right.
So immediately after the commissioner's decision, the NFL filed in New York. Presumably, their strategy was that it would be tactically a better jurisdiction. The next day, the Players Union filed in Minnesota, which got transferred to New York, and so the NFL is in New York.
The NFL thinks the Second Circuit is a more favorable court for their cause?
Whether it's more favorable or not, I mean, all types of strategic reasons, McGraw, go into deciding venue, New York versus Minnesota. But clearly they thought strategically the commissioner thought that it was better to have it in New York.
What does this say about if my boss calls me into the corner office and accuses me of stealing a laptop and let me see your phone and what do you know on me and they get does this have any bearing on any employer union relationship, or is this a one-off where this is so highly individualized and so highly unique that it's just a one-off?
I think it's highly unique, McGraw. There are arbitrations going on across the country today.
Yeah.
I think the more disappointing aspect of all of this is what's the message that young kids today take from all this? Because they're not going to understand arbitration and federal law and Second Circuit in Minnesota.
Right.
What does it tell the kids who are out there playing Pop Warner football or lacrosse or Little League baseball about right and wrong?
Right.
And that's the troubling part of this.
Well, what does it say to the two little ball boys who are not allowed back in the United States because they're in hiding? I sure would like to get them in an arbitration hearing and hear what they have to say.
Well, interestingly enough, Robert Kraft, the owner of the Patriots, accepted the commissioner's punishment that was meted out against the team, loss of 2 draft picks, $1 million fine, and suspending the 2 equipment folks.
Are you any guess as to how this appeal will go?
Very difficult to predict. I guess a couple things that we can certainly take note of. The Second Circuit Court of Appeals is one of the most distinguished courts in the country. It is a terrific court. So there will be a thorough and fair hearing. I keep coming back to where we started, McGraw, which is it is so extraordinary for arbitrators' awards to be overturned. Mm-hmm. If I were Robert Kraft, I would make sure next summer I had a backup quarterback under contract.
Interesting. In terms of how this works out, are they going to go back and testify in front of this 3-judge panel, or does this 3-judge panel already have all the information and they're just going to read it?
With an appeal, McGraw, there's no testimony. They will have the written record. The parties will file briefs, and I think it's most likely then there will be oral argument where the attorneys will appear and argue to the 3 judges, no testimony.
We can only hope that the Patriots get back to the Super Bowl and they rule 3 days before the Super Bowl. Greg Willard, KTRS legal analyst, a great guy, White House staffer, attorney for Gerald Ford, and a professor of law at St. Louis University. Have a good weekend. Thanks for coming in.
Thanks, McGraw. Good to be with you.
9:22 here, Big 550 KT.